Good morning to those in the Cook Islands and New Zealand, and good evening to those who are listening in the United Kingdom. And welcome to the Judicial Committee of the Privy Council. We are hearing an appeal and cross-appeal from the Cook Islands in the case of William Framhein and another against the Attorney General of the Cook Islands concerning the legality of regulations and a fishery plan for the Seine Fishery, primarily of Skipjack tuna, within the exclusive economic zone of the Cook Islands. This is a 2-hour hearing which has been arranged because Council cannot travel to the United Kingdom during the pandemic, and the different time zones militate against a longer remote hearing. To compensate for the shortness of the hearing, the Board authorised the parties to submit longer written cases than are normally allowed. We have considered those cases and given the parties some questions which we wish them to address. The appellants are represented today by Mr. Isaac Kaka and Mr. Jack Cundy, and the Attorney General is represented by Rebecca Rose and Alex Herman. The panel today comprises me, Lord Hodge, and sitting with me is Lord Briggs, Lord Leggett, Lord Burrows, and Lady Rose.
Hello.
If I could remind everyone who's not speaking to have their microphones muted, we won't get any feedback. And I'll now invite Mr. Hikaka to address the board.
Thank you, my lord, my lady. First, we would like to express on behalf of both parties the appreciation and thanks for the board accommodating this sitting in this way, given the unusual global circumstances. I propose to begin by addressing the appeal points, which I'll call the Aronga Mana issues, before then turning to the cross appeal or the environmental issues. And I propose to address the appeal in 4 stages. First, to identify the issues and the key issues that there are with the Court of Appeal decision and address the relief sought by the appellant. Then to examine Article 66A of the Cook Islands Constitution, and in doing so address the Court of Appeal's decision in Hunt and de Miguel and the correctness thereof. Finally, third, addressing the scope that the appellant says still remains for the operation of custom in the light of the Marine Resources Act and the role given under that Act to the Ministry of Marine Resources. And then finally to address the board's question as to whether and why it is appropriate for the board to intervene in this matter. And so through that, I hope to address the 4 questions the board has asked, though in a slightly different order, if that pleases. I turn to first the main concern that there is with the Court of Appeal decision. Obviously, there is a concern that as a result of it, there is no consultation with the Aronga Mana. The main concern really is, as part of the board's reasoning, as part of the Court of Appeal's reasoning, it renders a constitutional provision nugatory pending future legislation. It decides that Article 66A(4) of the Constitution will have no effect until Parliament passes another law. And that is, we submit clear from the judgment of the Court of Appeal at paragraphs 135, 144, 146, and 232. I can take the board to those if it would be of use, but all of them say that Article 66A(4) will not be given effect by the courts unless Parliament passes a statute that for the purposes of the Constitution, defines the Aronga Mana, how it is to be composed, and potentially how it is to make its decisions under that statute. This means in our submission that the effect of this for this case is that as a result, the Aronga Mana, despite their customary role as tiaki, guardians of resources, was not involved in this decision and will not be involved in any decisions going forward with relation to consideration of use of resources under the Fisheries Plan. So the relief that is sought here is purely forward-looking. It is declaratory. There is no challenge to the relief that is being granted to the by the Court of Appeal regarding the regulations, the plan, or the agreement. So we are not seeking to have them set aside anymore. The Court of Appeal considered that application, declined it, and so we're not seeking to revoke that. What we are doing is looking for declaratory relief, if you will, about the way the Aronga Mana ought to be treated and the way Article 66A, and in particular Articles 66A3 and A4, are to be considered going forward. In formal terms, the declaration that is sought is that the Crown must consult with the Aronga Mana going forward as a key stakeholder under the Fisheries Plan, requirement for biennial reviews of that plan. So the formal relief sought would be a declaration that the Aronga Mana must be consulted under the key stakeholder phrase. But of course, a lot of this is likely to come down to some of the aspects of the reasoning will also be important. To be candid with the board, of course, were it not for the decision or the decision of the Court of Appeal around the effect of Article 66A4, there's a real chance this appeal would not have been taken by the Aronga Mana because it might not have reached that public importance threshold. The finding that a constitutional provision has no effect, however, certainly meets that threshold in our submission. There is something of a tension now in this case. The appellant ran this case, as the board will see, relying on Article 66A4 as a major plank through which it was to prove the custom that it said existed. It turns out that according to the Court of Appeal's decision, there would have been no way the appellant could ever have won that case based on Article 66A4 because the lack of a definition of Aronga Mana in that constitution apparently means that the Article 66A4 has no operative effect. And that is a result that did come as a surprise, because even in the earlier decisions where this article had been identified, and which I will address with the board, it was recognized that there were difficulties potentially in the provision, but it was not suggested that it had no operative effect. Submit a good starting point for the consideration of custom and this Article 66A is Article 66A3 of the Constitution, which can be found at page 1770 of the record. That clause provides that custom is to have effect, custom and usage shall have effect as part of the law of the Cook Islands, unless inconsistent with the Constitution or an enactment. So in our submission, and the submission is backed up, we say, by prior decisions of the Court of Appeal, including Hunt, which I will take the board to, and in the Hansard material, that this is a provision intended to give strong support for the role of custom in the governance or regulation or legal framework of Cook Islands society. The Court of Appeal's first and main major consideration of this section up until this case was in the matter of Hunt and de Miguel. And if I could ask the board please to turn to page 2300 of the bundle, where page 56, there is a helpful summary of the Court of Appeal's reading of the sections. Just to clarify for the board asked whether there was agreement between the parties that the Court of Appeal's approach in Hunt to the interpretation of Article 66A, in particular 66A4, was agreed. And I can confirm that the parties do agree that the Court of Appeal's interpretation of 66A4 in Hunt and de Miguel is correct. What I would like to highlight from paragraph 56 of the Court of Appeal's judgment on page 2300 is its finding that the effect of Article 66A3 is that custom and usage shall take precedence in the Cook Islands. The emphasis there is that of the Court of Appeal, unless expressly ousted by statutory law or else inconsistent with the Constitution. And we submit that as correct and appropriate. I then may turn to Article 66A4 and the consideration of it by the Court of Appeal. Article 66A4, found back at page 1770, is, we submit, probably best viewed, as the Court of Appeal does, as something akin to an evidentiary section. It provides that for the purposes of the Constitution, an opinion or the opinion of the Aronga Mana of the island or waka to which a custom, tradition, or value relates as to matters relating to or concerning custom, tradition, usage, or the existence, extent, or application of custom shall be final and conclusive and shall not be questioned in any court of law. What we say and what the Court of Appeal in Hunt said was that this effectively provides a mechanism through which evidence of custom is to be recognised, and if evidence is provided in that form, then to adopt the words of the Court of Appeal, the court does not go behind it. So it's not an ouster provision. It doesn't oust the jurisdiction of the court, because the court still has the role, and we submit two major roles. The first is consideration of whether the law, whether the custom is consistent with statute or the Constitution, because if it is not, then the custom will not have effect. But if it is, then the court still has the role of applying that custom to the facts of the particular circumstance before it, applying it in the same way as if it was law, because that is the effect of Article 66A3. This Article 66A3 and A4 mechanism we submit is appropriate given the nature of custom in the Cook Islands. And we refer in particular here to the decision of the board in Brown and Munakoa. And if I could bring the board to that earlier decision at page 2246 of the bundle, of the record rather. And paragraph 16 of that decision, where the board notes that this was in consideration of whether custom fell into being need to be proved under the Angu and Ata approach. And the board recognised the difference in a colonial context, in particular in relation to the Cook Islands, when it said there are practical and conceptual objections to this approach in a colonial context, which apply a fortiori to the law of a sovereign territory such as the Cook Islands. In England, custom is a derogation from the ordinary law of the land, but native custom concerning land tenure and succession to land in the Cook Islands is not a derogation from the law of the land. Subject to statute, it is, again the emphasis of the board, the law of the land.
Yes, Lord Brixham, I recall the case.
Yes, my lord. And courts said courts take judicial notice on their own law. The need for evidence is not conceptual or legal, but purely practical. The custom has not been codified. It is not necessarily uniform across the different islands and tribes. Judges are not indigenous. For all these reasons, the court may find it difficult to take judicial notice of some points of customary law. Now, we respectfully submit the same comments apply to other forms of custom, not just land and succession. What Article 66A4 does, we submit, and I will return to this point later in the submissions, is it provides a good mechanism that recognises that with respect to questions of custom, there are non-Indigenous judges making those decisions. So the best and appropriate way to have that custom before the court is through the opinion of the Aronga Mana. That case did touch upon Article 66A4, but did not need to decide the point that is before the court, before the board today, because this is actually the first time that there has been a statement of evidence that in our submission is, or certainly purports to be, an opinion of the Aronga Mana as to custom in evidence. The matter's come up 3 times before as to our researchers. The first was in Hunt and de Miguel. There was no evidence of an opinion of the Aronga Mana. All there was in that case, and this can be seen at page 2287 of the bundle, paragraph 19, all there was in that case were submissions by one of the applicants asserting that there were 12 persons constituted the Aronga Mana of Tautonga, which is one of the waka of Rarotonga, or at least a majority of that, and the case proceeded on the basis of his submissions, no evidence as to any opinion. So unsurprisingly, the court said that is not what is envisaged in any way by Article 66A4. In case it is of assistance to the board, the Cook Islands is made up of 15 islands, 15 main islands. Custom across those islands is often similar, though not necessarily the same. So that's the reference to islands. Waka can often be probably best thought of as, say, a tribe, closest to, say, an iwi in the New Zealand sense, if the board is familiar with that. Waka is the word for canoe, which is how the tribes originally arrived. all the islands, there's no difference between islands and waka in all of the Cook Islands except for the most populous island of Rarotonga. Rarotonga holds roughly 2/3 of the population, if not more by now, because of the effects of migration. And it has 3 waka in it, and each waka may have its own different customs potentially. In this case, the evidence is that the relevant custom is the same across all the islands and waka where there is evidence. So that
when one speaks about a tribe in a waka in Rarotonga, is that equated with a geographical district? Do people from a particular community tend to congregate in one part of the island?
Yes, my lord, that's exactly correct. The island is divided into effectively 3 geographic districts, Ta'o, Tonga, Takitumu, and Waikura.
Thank you.
And those relate to the islands as well. It's roughly the northern part, the eastern and the western parts.
Thank you.
In Brown, as my lords Hodge and Briggs may recall, in that case too, there was no evidence of an opinion of the Aronga Mana, or even claiming to be. In that case, it was claimed on appeal for the first time before the Court of Appeal and then subsequently before this board, that an opinion of the Kortenui or the House of Araki was an opinion of the Aronga Mana for the purposes of Article 66A4. And the board noted at paragraph 34 of its decision that there was no evidence that that was actually the opinion of the Aronga Mana, so they did not have to decide that because, again, there was nothing that actually purported to fulfill the criteria of Article 66A4. The final case referred to is the Tupa case, which can be found, and the relevant section, it's a long case, and I won't take the board to it, but the relevant section is found at page 273 to 2373 through 2374 of the bundle at paragraph 113, where again, in that situation, one of the applicants was asserting that they were representing the Aronga Mana and providing just through submissions, not through evidence, that of what the claimed opinion of the Aronga Mana was. So this is the first time that there is actually a document purporting to be a proper opinion of the Aronga Mana of various waka or islands. And it was the opinions, which are found at beginning at pages 1411 of the bundle, and that is for the island of Achu, page 1417 for the island of Aitutaki, and 1436 for the 3 waka of Rarotonga. All of those were made with reference to the factors that the Court of Appeal identified in Hunt and Demigwell. And those factors are at page 2306 of the bundle, paragraphs 74 through 75. And the main factors the Court of Appeal said it would expect to see are a statement as to the composition of the Aronga Mana, and all of the opinions that are before the board and were before the High Court and Court of Appeal have that. A statement that they had formed an opinion as to custom, and that is also present. By way of a formal document, and again, that is what is present. And that it is before the court as sworn evidence. And again, that is before the court. So, of course, and I'll return to the effect of that, I submit, in a moment, but of course all this is for naught, as the board identified in its question, if the Marine Resources Act leaves no room for the operation of the custom. So I'll now address that question. What scope is there for customary law to preserve a suggested role of the Aronga Mana as tiaki, given the Marine Resources Act empowers the Ministry of Marine Resources to regulate fisheries? Our submission is that there is still a real role preserved. To be clear, the role that has been argued for is one of that the Aronga Mana must be consulted concerning fisheries proposals. So it's a consultation role we submit is how the tiaki traditional role now plays out in the modern context. And that's been consistent in our submissions right from the High Court, and you'll see that through the judgments. At a heart, the submission is that it is not inconsistent with the Ministry of Marine Resources making the ultimate decisions, but that they must consult with the Aronga Mana in making those decisions. So that's how the two work together. When we consider this question of operation, we submit that the starting point is that laws should be read so as to operate together if possible. And we don't think that's a startling proposition. That's the usual approach taken with regard to two different laws, where there's tension. And given that under Article 66A3, the custom has the effect of law, it should be treated the same way. So can it be read together? Further, we submit that inconsistency is a high bar. We referred to that paragraph 56 of Hunt at page 2300, where it said that in order for custom to be overridden, it must be express. Now, we also see a similar approach that there must be a that Parliament must use clear words to say that custom is to be overridden, given its effect as law, from the very recent decision of the New Zealand Supreme Court in the Trans-Tasman Resources case. Now, there are, of course, a multitude of these decisions that say this, but we've concentrated in particular on this most recent decision of the New Zealand Supreme Court for a few reasons. One is because it is a court of high authority. The second is because it is very recent. It came out, I believe, about a month ago. The third is that it also examines matters in the environmental space, which is analogous here, and also it and also.
I apologise, Mr. Ikaka. My lights were meant to be put on permanently, but they're on they remain on a timer. So if I get up to wave my hands around, please bear with me.
I also have now to get up and wave my hands around, so my light.
This is environmental responsibility getting in the way of elegance, I'm afraid.
And of course, my clients applaud that. The fourth reason as to why we submit the New Zealand Supreme Court's decision is of most use of all the foreign decisions is that it also considers the rights of Indigenous persons. And as this board has recognised in the Taviuni and Tumu decisions and referred to again in the Brown and Munakoa decision, there is a lot of similarity between Cook Islands Māori and New Zealand Māori in terms of approach to custom. So in that decision, I won't take the board to it at this point given time, but at page 2788 at paragraph 296, and then also at paragraph 151, they say that if Parliament intended to write these matters out, they should be clear in doing so. Rather than cutting across the duties or the role of MMR and the purposes of the Marine Resources Act by including this consultation matter, we submit that it would actually enhance the effectiveness of the of marine resources in the Act. It would speak directly, we submit this consultation obligation speaks directly to what is sought at paragraph 4D of the Act, which is at page 1850 of the bundle. And that is the paragraph, you'll see, or the board will see that there is actually no D in front of it. The Roman numerals go 2, 3, and then restart at 1, but that's an error in the drafting by Parliament. So that is actually 4D. Talks about the maintenance of traditional forms of sustainable fisheries management, protection of the interests of artisanal fishers and local island communities, including ensuring their participation in the management of fisheries and aquaculture, and broad participation by Cook Islanders in activities related to the sustainable use of resources. Consultation with the Aronga Mana enhances and does not cut across those statutory duties. It would also enhance...
Mr. Hukaki, could I just ask a question as to how precisely you are getting the consultation obligation? What's your exact formulation of how that arises?
I can do that, if I may, refer the board to one of the statements. So start at page 1420, this is one of the statements for the Statement of Custom from Aitutaki. At paragraph 13, as a matter of traditional Maori custom, the Aronga Mana are the tiaki, guardians of the moana, including the kaimoana. And you will see at paragraph 16 that it is matter of custom, the Aronga Mana must be informed of proposals in relation to kaimoana so that they can carry out their rights and responsibilities in relation to the resources. So we submit that a guardianship role is one that involves being told about what is planned for a resource so that one can consider how that is to be used. And we accept that the ultimate
problem with this formulation of the custom is it seems to be the wrong way around for you, because it says that the Aronga Mana should be informed so that they can decide what they're going to do with their rights and responsibilities. It doesn't say they must be asked for their opinion so that the Secretary of State can take that into account in exercising his rights and responsibilities.
Yes, my lord. That is, and we submit that that is because originally the custom would have been as stated, that the Aronga Mana would have been the decision maker here. That decision-making role is clearly now with the Ministry of Marine Resources. But our submission is that that does not therefore take away the entirety of the role of the Aronga Mana in this activity. That the other aspects of that role, whilst they're not to the ultimate purpose of making the decision, are still relevant and respect should be given to that traditional role of the Aronga Mana.
But the obligation to consult, assuming it to exist, can't itself be a custom, can it? It has to be something you imply in the Constitution or read in the Act to take account of custom.
I'm sorry, my lord, I missed the start of your question.
The obligation to consult can't itself be rooted in custom, can it? There is no such custom to consult for the purpose of the Marine Insurance Act, the Marine Resources Act. So you have to find the obligation to consult somewhere else, the Constitution or the Act.
On that point, I would differ from my lord. I would say that the obligation to inform of proposals is an aspect of consultation, that people did not customarily just go out and do things with the Aronga Mana, and so that without the Aronga Mana's permission. So that informing them is part of the customary duty and thus reflected in consultation. But also we say it is reflected in, for example, Article 4D, which does talk about the need to involve local and Cook Islanders and traditional practices. So it's also found there. The evidence more broadly also speaks to that the importance of conservation and customary knowledge in the way in which resources are operated at custom by the Aronga Mana. And so we submit it would enhance the preservation of those techniques. For example, one of the affidavits at page 239 talks a lot about traditional practices with regard to fisheries. We also note this is not a surprising thing. There's no inherent difficulty in the ministry and Aronga Mana working together. There is evidence that they have, for example, in the imposition of Rāui, and that is found at page 668 of the bundle. And also, this obligation would be construed, would be consistent with international instruments. The Crown refers to the FAO, one of the principles of international fisheries management referred to as soft law. And at page 2875 of the record, that document makes specific reference to the need that states should seek to identify relevant domestic parties having a legitimate interest in the use and management of fisheries resources and establish arrangements for consulting them to gain their collaboration in achieving responsible fisheries. Now, because that is soft law, it's not a direct and binding obligation under section 3.3, but we submit it as still relevant to the consideration of what can be done. We also note that this approach we advocate is consistent with the approaches in other jurisdictions. We've set out most of these in our submissions, but I will put some particular emphasis on the New Zealand approach for the reasons set out earlier. In that situation, the New Zealand Supreme Court acknowledged that customary interests were important, even though the decision was to be made by, in that case, the Decision-Making Council of the Environmental Protection Authority. That's found at pages 2739 and 2788 of the bundle. And I'd also like to emphasize the comment made by His Honour Justice Williams, Justice Joe Williams, in the New Zealand Supreme Court, that there is an importance in recognising these through the Indigenous or customary lens, and that's at page 2788 of the bundle. Here, the Aronga Mana provides that customary lens. So, His Honour Justice Williams refers to it as to not solely through a Pākehā lens. In New Zealand, that means a Western legal framework, as opposed to a Maori framework. And that we submit is also important in the Cook Islands. The evidence is replete with terms such as tiaki, tauporupuru, rāui, household gods. Those make much more sense when viewed through the Indigenous lens. Now, we submit, in New Zealand, that was founded on principles of the Treaty of Waitangi, which there's no statutory requirement for these matters to be taken into account in New Zealand, yet the courts read them in. In the Cook Islands, given Article 66A(3), we submit that provides a much stronger foundation for doing that. This is not looking at foreign cases, we submit is not a threat to the independence of the Cook Islands. The board and courts regularly look at other states. Now, finally, why is it appropriate for the board to intervene? We say it's appropriate because the intervention is called for because the lower courts erred in law rather than there being concurrent findings of fact. The first error we submit is that the minister couldn't contemplate custom, that such a custom existed. In short, we say because custom is a question of law, not of fact, the Crown cannot plead ignorance of the law. Of course, engagement with the Aronga Mana would alleviate any such concerns about difficulty finding custom, and we submit this is not overly burdensome. As we've set out at page 1560 of our submissions at paragraph 29, there are a multitude of statutes in the Cook Islands that show the Crown needs to engage with the Aronga Mana. So this is not adding any real extra burden there. It must be, so the difficulties that apparently exist must exist in those situations. We also submit the custom is clear on the clear statements and the opinions. And the final concern was about the clarity of who the Aronga Mana are. Now we note there are no statements and evidence challenging that the Aronga Mana listed as signatories in these opinions are the Aronga Mana. If the Crown wished to challenge that, they should have. There are statutory definitions.
Can you just help me, Mr. Hikaka? I haven't quite got a clear idea in my mind whether the Aronga Mana description of an individual who qualifies to be part of an unincorporated group, or whether it's a description of the group. And one sees the language used in both those ways slightly indiscriminately.
I think the better approach, my lord, is the first one, is that an Aronga Mana is somebody who holds under native custom and usage a title, and when they all come together, then is the Aronga Mana as a whole. Aronga Mana basically just means people of mana, people of authority, but the statutory definitions, which of course we submit were referred to in Hansard when this was being passed, locate them locate them as the holders of traditional titles in the Waka. And we have set out those statutory definitions at paragraphs 30 to 32 of our submissions. And I note that one of the statements in Hansard by the member Dr. Rabati noted that the Aronga Mana's role on island councils in the debate, and the definition of Aronga Mana in the relevant legislation he was referring to. He was referring to the Outer Island Government Act 1987, section 5(1)(b), that has the same definition as section 4, subsection 1 of the Island Government Act 2012 through 2013, which is included in our submission. So people at the time knew they were referring to the Aronga Mana as these titled holders. So to summarize the section and then to move quickly on to the cross appeal, the issue is that the Court of Appeal's decision has removed the recognition of custom through the constitutional means. It's taken it away from the constitutionally mandated traditional protectors and holders of custom, the Aronga Mana, and placed it in the court. And I mean no disrespect at all to this board, the Court of Appeal, or the High Court when I say that the judges on all those courts are not Indigenous. Indeed, the board recognised that itself in Brown and Munakor. And the Constitution addresses this by having the questions of custom decided by the Aronga Mana. The Court of Appeal's decision removes that and brings it to the court, and we submit that that cannot be correct, both as a matter of simply approaching it from fundamental principle that courts strive to give effect to the law, not give it no effect, but also in the circumstances of the Cook Islands, it is appropriate. If I may then turn in the last 8 minutes to the question of the cross appeal. And in short, my lords and my lady, we support the findings of the Court of Appeal for the reasons that they give. The matter can be most succinctly distilled down to the following. The best evidence the Crown had when it made the fisheries plan was that of the modelling under the Lahode report, found relevantly at pages 780 through 782 of the record. That modelled 1,000 days of fishing, with only 350 days of those being FAD, fish aggregating device fisheries. It identified a strong issue of mortality of juvenile big-eye tuna when FADs were used, and it identified that the northern part of the Cook Islands exclusive economic zone was one of the most favourable spawning grounds for big-eye tuna. The board has asked about the significance of that, and we submit that the significance is apologies, I'll get my note on this. The first is that there is evidence that bycatch of juvenile big-eye tuna in particular is a lot larger in, when you use FAD, so spawning ground are where big-eye tuna will be more juvenile. In terms of whether the FAD ban months coincide with the spawning period, there's no direct evidence. The only evidence we have is that Tropper is found at page 867 of the bundle, and that is a part of the Western Central Pacific Commission stock assessment for big-eye tuna, and it finds that tropical tuna spawning does not follow a clear seasonal pattern. So there's no evidence that it spawns during the months of when the FAD ban exists, which are the colder months of the year, of course, being in the southern hemisphere. And there is evidence that tuna prefer to spawn in warmer waters. That's found at page 380. Sorry, no, that's at 7.6 of the Lahode report, that they spawn in warmer water, and the evidence of Dr. Daniel Pawley is where we get the evidence that FAD setting are more detrimental to juvenile big-eye tuna. Now, in the face of all of that, the ministry authorised 1,250 days of fishing, so a 25% increase on the model. They said that all of those days could be done by FAD fishing, as long as it wasn't done within those 4 months. All the other days could be FAD set. And there was no geographic consideration of the matters around the exclusive economic zone. We find no reasons under the evidence were given as to why that was increased. The only evidence is the Secretary's second affidavit, where he says the level of allowable fishing in the Cook Islands exclusive economic zone was determined after careful consideration of science and catch history. That's at paragraph 38 of that affidavit, page 446 of the bundle. Given we know what the allowable fishing was, that can't have been correct. There was no extra scientific evidence to give careful consideration to other than the reports, none of which were on point. In terms of the other questions that I can answer for the board, because some of those questions...
Mr. Kika, the Lady Rose would like to ask a question.
Can I just ask, what difference does it make whether the Cook Islands has 1,000 days or 1,250 days, given that the regional agreement sets an upper limit of 64,000 days, so that if the Cook Islands had only applied for 1,000, the other 250 days may well have been taken by somebody else who would have caught tuna on those days outside the New Zealand EEZ?
Well,
The Cook Island EEZ. Yeah.
A couple of points. One, we submit that any increase, given the fish stock was already overfished, any increase in that would be of significant potential for significant harm and therefore needed to be justified in accordance with the international regulations and the precautionary approach which that's required. Secondly, there is a difference we submit in fishing in a spawning ground where you're more likely to catch juveniles and thus encourage fishing down the food web than fishing outside of those grounds and fishing less rather than fishing more. And also we respectfully submit that it's not necessarily the case that if the Cook Islands hadn't given those days, they would have just been taken up by someone else and fished outside the EEZ. People are paying the Cook Islands to fish those days in their waters as opposed to just fishing them on the exclusive economic zones, outside the exclusive economic zone. So there must be some reason for that, and that's addressed at in the affidavit of of Dr. Pauly.
Yes,
that point, my lady.
The point appears to be that the EEZs contain the best fishing grounds, and the deep sea doesn't have such resources.
Yes, my lord, exactly. Where, as fishermen will say, where one fishes can make a big difference to what one catches. Then the only point I would make in the last 30 seconds is that there is no inconsistency between the international regimes and requirements of an environmental impact assessment at local level. Indeed, for the very reasons that it matters where you fish, it actually enhances the international regime if individual states do provide proper analysis of what's going on in their waters and proper consideration and proper approaches to that. Indeed, that's why the regime is set up to provide assistance for small island developing states to do exactly that. And I see my time is at an end, so unless I can be of further assistance there, Board.
Mr. Hikaka, thank you very much for your clear submissions. We will hear you again in reply in an hour's time. Thank you very much. Ms. Rose.
In the interest of time, it's probably easiest for me to start with just making a few brief observations around the nature of the Crown's case and summary, and then move to the board's questions circulated yesterday before coming back and touching on some points in response to my learned friend's Aronga Mana submissions, and then also responding to the extent I haven't to his submissions about the EIA cross appeal. So just in terms of why this appeal is significant from the Crown's perspective at fishing level, the Crown very much sees this case as one which has strong potential to undermine regional and international arrangements which have been put in place for many, many years, dating back to the late 1940s, early 1950s. The UNCLOS Treaty, which is of course 70s and 80s, is a much more recent invention that created the EEZ. And that in itself, along with everything else that UNCLOS does, is a very fragile compromise of everything that goes on in oceans, whether it be navigation, freedom of fishing, etc., etc. And your honours will appreciate that fish like tuna, they do swim, they don't respect geographical boundaries, and they are a straddling stock, or a highly migratory fish stock, which is subject to what's well known in economics as the tragedy of the commons. And what the regional regimes have put in place is a measure which sees both the EEZ and the high seas, as they are defined under UNCLOS, regulated consistently. It does that through mandatory, and I note that the Court of Appeal referred to these as recommended or recommendations, but they are mandatory CMMs, conservation and management measures, that member states under or parties to the WCPO Convention must implement. And the system which is set up through the WCPO Convention, UNFISA and UNCLOS puts in place a regime whereby states can cooperate together and discharge their obligations under those regimes. And the reason the regime sets it up that way is so that small island developing states such as the Cook Islands aren't put to the huge expense of doing assessments on their own or trying to make assessments of stock without access to the best science. Both the Court of Appeal and the High Court have accepted that the WCPFC has access to the best science available. All of the individual member states under those conventions also have the right to have a representative sit on the science and technical committees. So it's not a huge leap of logic to attribute all of that knowledge that the WCPFC has to those individual member states. And as Justice Potter found in the High Court, the Cook Islands was entitled to rely on that CMM 2012-01 in terms of the significant body of technical work which sits in behind it and the negotiations which went on around it to land on the particular terms that my friend has mentioned some of, those being the 3-month mandatory restriction on fads from July to September, and then the optional 4th month of either October or a 33% reduction essentially of average fad numbers across the year. The Cook Islands happened to choose adding a 4th month of October, and that condition is included on the back of the licenses, which are in the record of the case as some sample licenses. So from that perspective, where you are dealing with a highly political issue such as fish, because as my learned friend has also mentioned correctly, there is money involved in these access rights. The reason that there is money involved, though, is because part of the UNCLOS arrangement is that to the extent a state can't extract the maximum or the optimal level of fish from their EEZ, they must share the surplus with other coastal or landlocked states. And there's good reason for that, because traditionally the EEZs, as we now know them, were part of the high seas that everyone had the right of freedom to fish on. So it's deeply troubling to the Cook Islands, and I presume also for other states where the Privy Council ends up being the final court of appeal for them as well, to have and particularly those ones which are SIDS like the Cooks, to have an obligation imposed on them like this one, which costs them significant money if they are to be able to then participate in the regional frameworks going forward. And if they're not able to access the funding to do this work, which in my submission makes very little difference to the ultimate decision, or it doesn't protect the resource in any way, it doesn't stop countries or states from making a bad decision. All it simply puts in place is another layer of administration, so to speak, and questionable administration at that, because the simple fact of the WCPFC having the best science means those smaller states or individual states simply can't. So from that perspective, what it will mean is that we'll end up back in a scenario where the developed or the rich states have much better access to the fishing resources. The whole purpose of the 2012 CMM was to allow developing states to grow and develop their fisheries. And the board there will see, if you have a look at that 2012 CMM, that there's a distinction put in place between countries and jurisdictions which have a current limit of above 1,000 days, those that have no limit, like the Cook Islands at the time, which needed to notify a limit to the WCPFC by the 16th of November, and other countries which were capped at their existing limits. And in my submission, the very fact that the Cook Islands submitted the 1250 days that it did, and that it was considered by all member states, which are obliged to make a decision by consensus, and that they did so without objection, is significant from the perspective of, is there a state practice or a customary international law obligation along the lines that my friend contends? And in my submission, I know of no other country that is required to do this EIA assessment task or an EAFM assessment task along the lines that the Cook Islands has had imposed on it by the Court of Appeal. So in my submission, that in itself is a factor weighing against there being a state practice. And then more broadly, in terms of what it will do to the regional bodies themselves, UNCLOS is not unique, but certainly rare in the sense that it doesn't allow reservations in the same way that other treaties do. Article 309 is the relevant reference. And as a consequence, states must consequently implement all their domestic and other treaties which sit underneath it in a manner which is consistent with UNCLOS. And all of the regional treaties, the WCPFO and UNFISA, contain similar obligations that, from an interpretation or an application perspective, those treaties must be interpreted in a way which is also consistent with UNCLOS. In my submission, the Marine Resources Act simply implements the Cook Islands regional and international obligations. And it does that, A, because it's a dualist rather than a monostate, and B, because it's the natural place to do it when you're dealing with a specific statute about fisheries. And it does it through sections 3.3 and 3.4. What is significant in section 3.3 of the Marine Resources Act 2005 is that it doesn't mention being consistent with domestic law. It mentions being consistent with international and regional obligations relating to the conservation and management of living and non-living resources in the fishery waters. And the fishery waters are specifically defined to include the EEZ. And then in section 3.4, the Act provides that the provisions of this Act shall prevail in the event of inconsistency or incompatibility with any other Act or instrument having the force of law in the Cook Islands from time to time, except for the Constitution of the Cook Islands. And in 2017, that was added to with one small amendment of and the Marai Moana Act 2017, which I'll come to in terms of one of the board's questions about what that act did in terms of changes to the nautical mile limit. But in my submission, the statement in section 3.4 that the objectives, functions and authority provided under this act and the Cook Islands obligations, international and regional, are effectively discharged means that there can be no doubt that this is implementing UNCLOS, UNFISA and the WCPFO Convention. That then becomes significant when one looks to how that act itself must be interpreted, with the beginning words of Article 3.3, which also require the Act and all persons, which include the Cook Islands government and foreign governments and their subsidiaries in the definition sections, exercising or performing functions, duties or powers conferred to act consistently with those international and regional obligations. And Section 3.2 gives the Ministry of Marine Resources the principal function and authority for the conservation, management, development of living and non-living resources. So with that regime in mind, in my submission, there has been a very clear decision by Parliament to give the sole discretion around fisheries decisions to the Ministry of Marine Resources, or the Secretary, as long as he or she ensures that whatever he or she does is consistent with each and all of the international and regional obligations which apply. And that's probably a convenient point to also deal with the Environment Act, which my learned friend says creates an additional obligation. And Your Honours, the board will have noted that that isn't specifically addressed in my written or the Crown's written submissions. The reason for that is the Crown's position is that the Environment Act has no application. And there's several reasons for that. One is, while the Environment Act applies to the EEZ, it does so in a very circumscribed way. It applies to activities. It doesn't apply to the promulgation of regulations or the creation of fishery plans or exercising a statutory power. There is no tenable argument in my submission that simply doing any of those things can cause significant harm in the way that the Environment Act contemplates. Simply not an activity. When you also look at the application of Section 36 and Sections 50 and 51 of the Environment Act, what one sees in Sections 50 and 51 in particular is a list of things which are tied to discharges into the environment, construction of things in the EEZ, digging up a lagoon or silt and sand, etc. Fish is completely absent. And that is to be completely expected, given that there is a very specific statute, namely the MRA Act 2005, which deals with those matters. And on that point, I just again re-emphasise the Section 3 provision that to the extent there is any inconsistency between the MRA Act and the Environment Act, it's the MRA Act which must prevail. So in my submission, there is no room in the statutory regime, that being the MRA and the international and regional arrangements, for either the Environment Act to create an obligation to perform or undertake an EIA, or for a customary law international law obligation to arise either. And the reason for that is that even if one accepts that what we're dealing here with is not two competing customary international law obligations, UNCLOS being accepted as customary international law by a lot of commentators, but if it's just accepted as a treaty, the UNCLOS regime is by far the more specific, and the specific must override the general, that being the pulp mills or Nicaragua obligations. There are also significant distinctions to be drawn between the two regimes in which the pulp mills Nicaragua obligation arose. The sea is very different to a scenario, for example, where there's a river running through multiple states, or there's something happening in people or states' shared territorial waters. And it's certainly not industrial level harm like was featured in the pulp mills and the Nicaragua cases. So in my submission, the very carefully put together zones of the sea and the finely balanced compromises which all states have entered into under the UNCLOS and competing treaties regime ought to be respected and applied. And under that regime, states are entitled to rely on the assessments and the science that the regional bodies that they're obliged to be members of have done or created. And it's with that in mind that I come to the nature of the limit and how that was arrived at, it has been dismissed rather quickly, I would suggest, by the Court of Appeal and my learned friends, as distinct from Justice Potter in the High Court, as being something that was essentially just a few pieces of paper with not much more thought behind them or technical data going into them. But in my written submissions, you will all see that there is a very complicated process which goes on to come up with those CMMs by the WCPFC members each year and in between their annual meetings. There are a raft of papers circulated, and the treaties themselves provide for science to be supplied. So against that backdrop, where you have 1250 days against 64,000, as Milady noted, is less than about 2% of the total WCPFC limit. It's also significant to note that Tokelau, which has an EEZ of about a fifth of the size of the Cook Islands, has a limit of 1,000 days that was approved by the WCPFC. So on a relativity or a comparability measure, Tokelau, by some margin, is extracting a lot more fish out of its EEZ area than the Cooks is. And it's probably a convenient point to pick up there on a comment made by my learned friend that the context for this is a backdrop against which the stocks were overfished, and that's simply not correct. There was some overfishing occurring for certain stocks, namely big eye and yellowfin, but there was no overfished state of the stock. And the two things are different. One goes to the target point and one goes to the limit reference point. You can have a state of overfishing, but not have an overfished stock. If measures are not taken to reduce the mortality rate of fish, if you keep overfishing at the rates you are, you will likely end up with an overfished stock, but it is still possible for stocks to replenish towards the target reference point while overfishing is occurring. And the Lahode reports and the OFP reports are very clear on that front. I'll just read you on as a brief extract from the OFP report, which notes that significantly fewer skipjack, big eye, yellowfin and albacore are available. Although none of these stocks are yet considered overfished, assessments predict big eye will become overfished in the WCPFO unless fishing mortality for this species is further reduced.
What page of the bundle was that?
Sorry, my lady. It's $796.
Thank you.
And it's paragraph 4.4. And it's exactly that concern which is what led to the creation of the 2012 CMM, which is on page 808 of the record. And Your Honour, the board will see within that, I'll just take you to a few paragraphs. On the second page, they don't unfortunately have numbers of that document, noting, 1, 2, 3, the fourth paragraph down, that Article 30 of the Convention requires the Commission to give full recognition to the special requirements of states that are parties to the Convention, in particular small island developing states. And 2 paragraphs above that, recognising that the Scientific Committee has determined that the big eye stock is subject to overfishing and that the yellowfin stocks are being fished at capacity, reductions in fishing mortality are required in order to reduce the risks that these stocks will become overfished. Over the page, under the heading of objectives and general rules, what the CMM then does is put in place a series of limits that help ensure that the stocks will not reach an overfished state. It also adds to that by putting in place the interim measures, which start at paragraph 10 of the document. Those include the specific FAD recognitions, which I've mentioned, the first being that 3-month mandatory ban at paragraph 10, and then the optional choose one or the other of 11.1 or 11.2, the cooks choosing 11.1. It also then sets out a series of effort management. And it's significant that the WCPFC doesn't regulate by way of quota management or tonnage. It generally regulates by way of effort days. It then goes through and divides the states into those with differing limits, and it mentions the 16 November date at the bottom of paragraph 14 there. And at paragraph 15, it reinforces the need for states not to increase their fishing days on the high seas, which of course is where the freedom of fishing applies, subject to both the WCPFO and UNFISA requiring the CMMs for tuna to be consistent in both the high seas and in EEZs. Over at paragraph 24, it also requires states to submit FAD management plans and deals with the different types of fishing as well as other commercial fishes. And then starting at paragraph 32, it sets out a range of measures for the subsequent years 2014 to 17, including possible FAD closures as well as noting the special requirements again of SID. And at the back of that, in attachment A, the board will be able to see there the appendix around FAD management and the guidance at attachment B for reduction of FAD usage. In terms of the board's question around spawning, generally tuna are tropical fish, and this is a tropical tuna measure. Tuna tend to like the warmer waters for spawning, and it's no secret that the skipjack belt is closest to the equator, known as the equatorial band, and that's up in that part of the areas of EEZs and high seas where a lot of the spawning does occur. Given the size of the Cook Islands fishery, in my submission, even if the Cook Islands had completely shut down its entire fishery, not just put in place a ban on FADs for a longer period, or which it wasn't obliged to do, it would have made no difference whatsoever in a meaningful way to the overall status of the fish stocks. As I've said, the total size of the Cook Islands fishery is less than 2%. That probably sets up the.
Can I just ask one other factual question? You talked about optimum levels of fishing for conservation and sustainability, which might be thought to suggest that actually some level of fishing is good for conservation and sustainability, which seems a bit counterintuitive. One would have thought it's best if you don't fish them at all, they're most likely to be conserved and maintained. But you've mentioned a couple of times the optimum level and the fact that that's why the smaller islands aren't limited to their own fishing use. But is there anywhere in the papers where we see a description of how one arrives at the optimal level of fishing?
I can probably just direct Milady to Article 64 of UNCLOS, which is what requires, and I'll just read parts of it to you. For highly migratory species, which tuna are one, and that's through the annex to the convention, the coastal states and other states whose nationals fish in the region for the highly migratory species shall cooperate directly or through appropriate international organisations, those being the regional authorities like the WCPC, with a view to ensuring conservation and promoting the objective of optimum utilisation of such species throughout the region, both within and beyond the exclusive economic zone. In regions for which no appropriate international organisation exists, the coastal states and other states whose nationals harvest these species shall cooperate to establish an organisation and participate in its work. So in my submission, what Article 64 puts in place, and the comparable provision in relation to the high seas is Article 118, is a regime where states are allowed to fish up to an optimal level, which was traditionally seen as MSY in an economic sense. If you couldn't fish up to MSY under the old sense, then you were obliged to share the surplus. And that was because in the regime pre-UNCLOS's implementation, essentially all of the EEZ was part of the high seas, and states had an uninterruptible right to fish in the same way that the rights to navigation still remain under UNCLOS, etc. So what UNCLOS attempts to balance in a careful way is the right to exploit against the right to, or the obligation to conserve. And so it allows states certain sovereign rights, but only tied to things like fisheries, not over everything in the EEZ. And it then requires, as a collective whole, everyone to participate in a regional body so that it can be assured that there is cooperation at that level and management of the resource at that level to avoid the tragedy of the commons, which is the overexploitation of stocks. And if the duty to cooperate is given proper weight, and in my submission the Court of Appeal failed to do so, then the regime that UNCLOS implements and those under it should ensure that you don't end up with an overfished stock, but you end up with maximum exploitation, and states which rely on fish, particularly for their food supply, not necessarily as a money resource, have the freedom to continue to do that.
I wonder if I could ask a question now, please. I understand the importance of regional cooperation and the limited resources available to small island developing states, and the need for those states to rely on the wealthier states to carry out much of the science. But I don't see how, if a particular state had a spawning area which was sensitive, as we're told in this case, the big eye tuna spawning area to the north of the Cook Islands EEZ was, why it couldn't ask its fellow states to assess whether or not special measures should be taken in that particular area in order to protect the stocks there, while allowing fishing elsewhere in the state's EEZ. Was there anything to prevent that? And if it was done, how would it interfere with the necessary regional cooperation which you've emphasised?
In my submission, my lord, the spawning zones are things which are picked up specifically by the scientific and technical committees which are required to report to the regional bodies. And if there was concern by one or more member states about a particular spawning zone, that would absolutely have been picked up as part of that technical work. And in my submission, those technical committees are the best placed to be able to assess whether one particular spawning zone is more significant than another, whether it is in fact a spawning zone all year round or just for certain months of the year. Big Eye, as you will have heard, they don't actually have a particular spawning time of the year. Some will say they spawn all year round. Other stocks will tend to spawn in more specific months of the year. But tuna, as is noted in the Lahode report, are also subject to weather conditions, El Nino and La Nina. You get different modelling results with those. And it's perhaps useful to just emphasise there that the Lahode report modelled a certain scenario. And that scenario changed by the time the CMM was implemented, in that it reduces the amount of fishing by other states outside the Cook Islands water than what was expected. And that can be seen in the total limits that the WCPFC sets, as well as in the effort limit restrictions and in the FAD restrictions that it puts in place across the board, not just in the Cook Islands. So to the extent that states might want to dip in and dip out and do their own assessments, they are absolutely free to do so if there is a particular concern. But what it shouldn't be doing in my submission is undermining in any way the regional framework and the mandatory measures which the WCPFC and other regional authorities issue and expect states to implement.
My question was really directed to the fact that if one did do one's own assessment as a supplement to the regional work, that wouldn't necessarily undermine the vitally important regional work, which is necessary for all the states, but it is particularly important for the small island developing states, given their limited resources.
In my submission, sir, it really does run the risk of using bad science, for lack of a technical term, because particularly if it is a SIDS state, it is simply not going to have access to large amounts of funding to try and get data across the whole region. And tuna, by their very nature, don't stay put within geographical boundaries. So trying to assess what's in your particular EEZ, so to speak, on one day versus what's in the wider region is an incredibly difficult task. And I do submit that it also runs the risk of encouraging further litigation, perhaps similar or different to this, in the sense that if a state did have to do an assessment, it got some science that was different to what the regional body came up with, and it chose to follow the regional body. Is it going to have to then go through a judicial review process to justify why it followed the best science, or is it entitled to stick with its own science, and vice versa? And I suspect the outcome will depend on whether the state considers the report it gets to be better or worse than what the regional body gets. It also takes away from the balancing of particular states' interests by having one body that sets the regime and states complying with it by consensus. The moment there are departures from that, it does start to tilt the balance.
I see that, but could not a state ask the regional bodies, the WCPO members, if there is a problem within their EEZ on the science that they have? And it may be said, to the best of my knowledge, that the Cook Islands never asked the WCPO members whether or not that there was any particular sensitivity with these particular spawning grounds.
I can't confirm or deny that, my lord, but what I can submit is that, and I just direct the board to the references and the links within my written submissions, the CMMs are extensive, and those technical and science committees are similarly so. There are hundreds, if not thousands, of documents on those websites that all get fed through to the annual meeting of the WCPFC, and all of the members analyse, pull apart, and essentially have to be happy with what the particular states are individually doing, as well as what the regional body is doing as a whole. the very fact that when the Cook Islands submitted its 1250 days, there was no opposition to that 1250 day limit. And in fact, subsequent CMMs confirm that limit going forward in the same way that they confirm other states' limits. That in itself suggests that no one was unhappy in a meaningful way, at least.
Thank you.
So are you saying that within the scientific and technical committees, when they were arriving at the CMM, they would have looked at the spawning ground in the EEZ to see if anything further needed to be done, either by everybody or by the Cook Islands?
They would have had to, Milady, in the sense that the whole purpose of that 2012 CMM was to deal with the scenario that Big Eye was subject to overfishing, and that needed to be rectified to bring down the mortality rates. So that's where things like the FADs and the effort limit impositions become much more relevant in trying to deal with spawning issues. For some fish stocks, those 3-4 months will make a difference. And over a period of time, it's not out of the realm of possibility that they'll make a significant difference. What is also significant in that CMM is that they are defined as interim measures. The WCPC doesn't set and forget. These get reviewed annually to deal with, is your limit appropriate? Should it be adjusted up or down? How does that deal with the convention as a whole, based on the science that we've received? The other relevant factor too is that all states are obliged to submit catch data to the WCPC scientific committees. So they do know very well what is actually going on in the region as a whole, as well as individual states.
But I don't think, as a matter of fact, we know, or you can assure us that the spawning beds that were spawning areas that seem to be the critical question in this field, whether the WCPO members in fact looked at them one way or another.
In my submission, they would have to have looked at the spawning grounds across the region, not just for the Cook Islands. In the same way that the evidence that is before the board doesn't specifically identify the alleged spawning grounds of concern in a precise way, there is nothing in the record which will give the board comfort that this was categorically thought about and decided that this was all okay. My submission is that from the process that was followed and the science that the WCPFC clearly had to receive and did receive, and the CMM measures that they put to restrict the possibility of the tuna stocks becoming overfished. Skipjack were not at all. Skipjack are perfectly happy. It's just the big eye and the yellowfin at the time. Subsequent reports confirm that they are now in a state which is much closer to the target reference point. So clearly there has been a difference in the stock status as a result of the measures that have been put in place by the regional bodies. And spawning is just one factor within a wider regional management program of how you manage a stock. FADs and other things have their pluses and minuses, and they get regulated accordingly. Equally, the obligations to make available to SIDS access to be able to develop a fishery is something that the richer states have to sort of take on the chin with some limits on what they've been taking from the EEZs as well.
Thank you. I've given the shortage of time. I better let you develop your submission. Thank you.
That's okay. I'll try and rattle through the board's questions when I find the list again. Just to touch on the board's question 5 around the correctness of the High Court and Court of Appeal's views on those nautical mile limits. In my submission, yes, until Marae Moana, the limit was 24 nautical miles for all islands except Rarotonga and 48 nautical miles for Rarotonga. Under the Marae Moana Act, it was changed to be 50 nautical miles around all islands, including obviously Rarotonga. And the reason given for that in section 24 of the Aronga Mana Act is to protect large-scale, the purpose of this area is to protect the pelagic, which are tuna, bethalate, coral reef, coastal and lagoon habitats of the Aronga Mana, and large-scale commercial fishing in the area are prohibited, but other ecologically sustainable uses are permitted. Then dealing with in terms of question 8, did the government seek any assistance from the WCPFO specifically for funding? Short answer is no. Did it seek assistance in the form of deciding its limit? Absolutely. That went through the WCPFC process in the way that the WCPFC required, as set out in that CMM. And just in terms of other evidence in the record, I just note the affidavit of Mr. Hampton, which says that the Cook Islands limit of 1250 days is conservative and low by comparison to adjacent states and other SIDS. In terms of question 3 and the operation of section 4 and its interrelationship with Article 5 of the WCPFO Convention, in my submission, section 4 of the MRA applies when preparing the fishery plan, and it requires the minister or the secretary, as the words of the section say, to take into account certain principles and measures. The adoption of the tropical tuna or the CMM measure 2012 and others, however, do mean that the Cook Islands has discharged a good number, or is able to discharge a good number of the items set out in section 4 through that regional cooperation and reliance on the work that the WCPFC does. Under the WCPFO Convention, if a CMM is implemented, the member states take the state that's done that as being a compliant state, and it's taken to be a decision which is consistent with Article 5 of the Convention itself. So states don't need to go and do their own individual assessments to discharge Article 5, is the short point. They can rely on whatever work the WCPFC happens to do at the time. The whole nature of the UNCLOS, UNFISA, WCPFO arrangement is that they are precautionary. They don't allow what was the previous state of affairs before UNCLOS's introduction of a free-for-all or tragedy of the commons on the high seas. But the rights and obligations are balanced. In terms of the wider restrictions, I've mentioned that the Cooks participates actively in the WCPFC, but at a domestic level, it also has to license vessels once they wish to have access to that particular limit. And it adds licensing conditions, as that license I referred Your Honours to earlier mentions, where the FAD restrictions are put in. It also, in the licensing conditions, requires those foreign vessels to comply with all CMMs, as does UNCLOS itself. If you're a foreign fishing state, you must comply with all regs and rules. And it also receives routine data from all of those vessels, so it can monitor what is going on. A lot of that data is real time and it's shared with the WCPC and provides general ongoing monitoring of the fishery as a whole. I think in terms of the questions, correct me if I'm wrong, but I may have answered them all. If that's the case, I'll just, unless you're, sorry.
I think you haven't answered number one,
What's number one?
although it may be implicit in your submissions.
Ah, the concession point. Yes. Yes, I do renew the application. I'm not entirely clear why it wasn't dealt with specifically by the Court of Appeal, and to the extent the Court of Appeal suggests that the parties are agreed that there is no dispute around there being significant harm, I disagree with that. There was a formal written application made and a memo filed further to that with a response from my learned friends and a reply. Those were simply not dealt with. I would also make the submission that in the High Court, this was not run as a law of the sea case. It was run largely as a pulp mills Nicaragua case. So to the extent that there is any concession around significance, it cannot be a concession about Article 206 of UNCLOS. It must be confined to the Environment Act to the extent that there is any application there. To my submission, there's not, and also the customary international law obligation, which again in my submission is not. Unless there's specific questions on the concession. No.
I have a different question, Ms. Rose, if this isn't an inconvenient moment. The main thrust of your submissions on the cross appeal is that for the Cook Islands to have, as it were, gone off on their own and imposed bespoke restrictions within their EEZ would have run contrary to the regional basis upon which the whole scheme is structured. Now, Section 24 of the Aronga Mana Act, on the face of it, appears to do exactly that, namely to impose, in place of a previous ban, a 50-mile limit within which there can't, I assume, be any purse seine net fishing. Now, how was that, as it were, socialized with the regional committees, or wasn't it? Or was it just something the Cook Islands went off and did off their own bat?
So the UNCLOS regime allows states to regulate for the purposes of exploitation, conservation, development and management. And as part of that, states are free to put in place restrictions such as you can't fish in the 50 nautical miles adjacent to the territorial sea. But what states can't do is restrict the catch limits from within the entirety of the EEZ in a way that is inconsistent with UNCLOS. So if there is a particular reason, say for example, and I'm just making this up, to preserve turtles, a state is free to say, well, they operate in particular parts of the waters closer to shore, and we can therefore have deep sea fishing or pelagic fishing in other parts of the ocean to balance the ocean as a whole and as a working ecosystem.
Can you may not be able to remember it off the top of your head, but where do we find this permission within the UNCLOS regime to impose these coastal restrictions? I mean, don't worry now, it's probably buried deeply away somewhere, but if you could help with a page reference, it would be most useful.
I'll try and find the board, the article references that would support that submission.
That would be very hard. You obviously
you can submit them later in writing. That'll be fine.
Yeah.
Thank you, my lord.
Thank you.
Unless there are further questions on the EIA aspects and the precautionary approach, which in my submission is fairly well set out in my written submission, so I probably don't need to say more about that. I'll jump to the Aronga Mana issues just in response to my learned friend. In my submission, there are a number of fundamental problems with my learned friend's submission about reading in a consultation obligation into an act, which is a very specific act that could very easily have turned its mind to this issue, but chose not to. In addition to that, the Aronga Mana didn't pop up 15 or so years ago now, at the time the MRA was introduced, and alleged the various customs that they are alleging now. And I use the word plural customs there as distinct from my learned friend who has suggested that there is one custom on offer here. In my submission, when one looks at the evidence, and I have tried to assist the board with a table at the back of the Crown's Aronga Mana submissions around the inconsistencies in the customs between vakas and islands, and the number of Aronga Mana who are members of each of those respective entities, so to speak, and the reasons for that. In my submission, duties to consult ought not to lightly be imposed as a matter of law. There needs to be very good reason for it, and a lot of the reasons advanced by the appellants seem to focus on Maori culture or other Western nations with an Indigenous culture but still subject to a Western government. In my submission, those states tend to need a consultation obligation to the extent they are imposed a lot more than the Cook Islands do, because they are by definition an Indigenous culture. They govern themselves in that sense. They don't need to have something put into statute that records that expressly. And I'll just direct your honours to the reference in Tupa, which is in my written submissions, paragraph 198, which my learned friend took you to, which cautions against simply applying Maori custom to Cook Islands cases, and Tupa is a Cook Islands case. In addition to the issues about what exactly my learned friend would have imposed into the statute or the constitution, there are very real issues around whether the Aronga Mana are properly constituted. Yes, certain people have self-selected, so to speak, and said they are Aronga Mana with particular titles. There is, however, no evidence of when they were invested with those particular titles, where they got those titles from, etc., etc. There is also an issue around composition of the Aronga Mana and the definition there. I'll just note briefly the past decisions of this board and in the Court of Appeal cases where there have been suggestions of different Aronga Mana composition. For example, the House of Ariki and Kortanui being one versus those that have now signed the various affidavits they have. In addition to that, just because it's a useful example, Atataki has inconsistencies within it around what the particular custom is that is said to apply. On top of that is a very real issue around whether or not custom extends beyond the reef or is constrained by the reef. My written submissions deal with the differing interpretations of the chant. And again, the Tupa case says that from a customary perspective in the Cook Islands, it's understood that it extends from the reef to the ridge being the mountain, certainly not into the EEZ. And as I've touched on, the EEZ is a relatively recent creation. 1977 was the first act that's since been updated by various legislative regimes, but that's the point in the sand at which we're really assessing whether or not this is a custom of long standing, if it's to be applied at common law, or whether or not it's something that the various states have always, or the Wakaran Islands have always done. And I'll just note in terms of the different contexts that the Taranaki case that my learned friends took Your Honours, or the board to as well, in terms of a recent example out of the New Zealand setting, within that case there is comment that it doesn't immediately follow that the custom within the land applies to the EEZ. And I would submit that it's exactly the same scenario here. And that's dealt with at footnote 57 of my submissions. Then just dealing with whether there can be any scope for the alleged custom. It cannot be the case in my submission that a single Aronga Mana could provide an affidavit alleging a particular custom, and the court would have no further role other than to decide whether or not that was consistent with the Constitution or a particular enactment. If, for example, 3 Aronga Mana were to come to the court alleging different customs, there must be a role for the court to be able to reconcile which custom it prefers, who's got the greater authority, whether those people, self-appointed Aronga Mana or otherwise, have the better claim to asserting the custom, etc. And in my submission, that is completely consistent with the Court of Appeal's decision in Hunt and Demigale. Whilst it may be unfortunate and frustrating for the board and other members of the Cook Island public that Parliament has chosen not to fill the gap, in my submission, this is not a case where the court can involve itself in essentially rewriting a statute or writing new words into the Constitution. It is far from certain as to what Parliament would have said if it had turned its mind to it, and the explanation that was given in Parliament that people would know what this meant perhaps reinforces that there is sufficient uncertainty out there that does need to go back to Parliament to be dealt with. So unless the board has any questions around the Aronga Mana issues, I note that I'm pretty much at time.
I don't see any further questions being addressed to you, Ms. Rose. Thank you very much for your submissions.
Thank you, my lord.
Mr. Hikaka, your submissions in reply.
Thank you, my lord. The first point I would like to address relates to the questions my Lord Hodge and my Lady Rose asked around the spawning grounds and the interplay between the international regime and the domestic regime. The fundamental thrust of which I respectfully heard was, why could a domestic body not investigate, for example, the spawning grounds? And was this actually done by the Science and Technology Committee? We have found no evidence that the Science and Technology, the Science and Technical Committee of the WCPFC did look at spawning grounds across the entire EEZ, and I think my learned friend acknowledged that. So there's nothing in the evidence to support the submission that they did. But if one looks at the relevant instrument, we submit that actually supports the case that there is a role for domestic consideration of its own areas. In particular, I refer the board to page 813 of the record, which is in the 2012 CMMs, and paragraph 14 of that, which states that other coastal states within the convention area, other those referred to in paragraphs 12 and 13, that means that would include the Cook Islands, shall establish effort limits or equivalent catch limits for purse seine fisheries within their EEZs that reflect the geographical distributions of skipjack, yellowfin, and big-eye tunas and are consistent with the objectives for those species. Limits established pursuant to this shall be provided to the Commission. So what that is saying is exactly what has been suggested, that the CMMs themselves said you should look and see what limits you should impose in your area, having regard to geographic distribution, and then propose those to the CMM, to the committee. Now, there's no evidence that that was ever done by the Cook Islands. They just proposed the effort limits, and presumably they were approved, presumably because it was believed there was compliance with paragraph 14. One other point for clarification, my learned friend in response to the questions around the concession and the stated it was at best a concession in respect of customary international law and not UNCLOS. And a submission was made that the obligations in UNCLOS and the relevant international treaties around EIAs are different than those of the customary international law. That submission is incorrect as a matter of international law. It has been decided by the International Court of Justice ever since the Nicaragua paramilitaries case that treaty obligations and customary law obligations run parallel. That is reflected in pulp mills. It is reflected in the subsequent Costa Rica and Nicaragua cases where there were treaties as well as obligations, and it's specifically addressed by the International Tribunal on the Law of the Sea in its advisory opinion at paragraphs 145 and 148 of that decision, where they say that the obligation to conduct environmental impact assessments exists both under Article 206 and customary international law simultaneously. With regard to...
Do you have a reference for those paragraphs?
Sorry, my lord. Page 2649 and 2650. With respect to the points made about the Aronga Mana, the fact that the custom didn't, as my learned friend put it, pop up years ago, the Aronga Mana didn't pop up years ago, that's irrelevant. We submit it was raised when the Fishery Plan was implemented, which is all that's required. The submission that New Zealand or other jurisdictions are inapposite analogies because in the Cook Islanders govern themselves, with respect, is incorrect as it confuses the ethnicity of an individual with a customary structure of power and law. And again, this hearing and all the hearings are good examples of that none of the judges who have decided matters in this case are Cook Islanders. So to say, well, because a majority of the Cook Islands Parliament is Cook Islander, isn't an answer to the question of how does the customary structures and law interplay with modern or Western law. Also note that there were some submissions made about the extent of custom extending out beyond the reef, etc. I don't propose to go into those because that's again the role of the statements of custom by the Aronga Mana. It's That's the whole purpose of section 66A4, is to mean that those questions do not need to be decided upon by the courts, because the Aronga Mana has been given that role under the Constitution. And the final point I note here is there was suggestion that, well, we have some competing claims as to custom in this case. What we have is no challenge in a form. Sorry, I'll start again. My learned friend posited, well, what if we have multiple people claiming to be the Aronga Mana? Well, in that case, I accept there would need to be interrogation by the board as to which was the, or the court rather, as to who was the proper Aronga Mana, because presumably there will have been different sworn evidence on it, and that would have been challenged in terms of section 66A4. Whether or not that would happen is a different question, but it could. That would be determined in accordance with usual practices and principles. Here, we do not have such a challenge. The only sworn statements in accordance with Article 66A4 are the ones that have been put forward by the appellants. Of course, in some ways, all of that is academic if the Court of Appeal is correct, and Article 66A4 can have no effect at all until a definition has passed. And fundamentally, the most important part we raise of this appeal is that that cannot be correct. Unless there is, and I hope I've as well answered all of the questions from the board to the extent that they applied to the appellants or cross-appeal respondents. But if not, please let me know any way I can assist further.
I don't see any request for further information. Well, thank you very much for your submissions. The board is very grateful to Council for their focused submissions, and also to those who have assisted in the presentation and the preparation of this appeal and the cross appeal. The board wishes especially to thank the appellant's legal team, who have acted without fee, pro bono publico. We are very grateful for that. The board will consider with care all that we've read and heard when deciding how we will humbly advise Her Majesty. And we will now adjourn. Thank you.